Franklin County Commissioners meeting, April 9th, 2019.
Give you a heads up. All right. It is 9 o'clock. We're here for a Tuesday normal board meeting. We have all three commissioners on board this morning. And Mr. Johnson, our administrator, and Karen, our clerk. And if you would join me with the Pledge of Allegiance, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. I think our first order of business this morning is our reps from Olympia to contact. This morning.
Try the other number here if they don't answer.
Good morning.
Good morning, gentlemen. This is Keith Johnson with the Franklin County Board of Commissioners meeting. You are on.
How's it going?
Good, thank you.
Morning, Zach.
Morning, Zach.
Morning. Oh, well, you guys all ready for us and ready to get the good news this morning?
Good news first.
There's a lot of votes being taken this week, Zach. Tell me the good news at the end of the week.
Oh, okay, well then we'll wait on that. The best news we can give you a day that it's not raining here.
Yeah, that's what I thought.
I guess it's kind of just to tell you guys where we are and where things are standing right now. They had appropriations and Ways and Means, transportation all weekend long. I guess not Sunday, but all Saturday. There were really long committees. They're doing a little bit of work here the first half of this week. Cutoff is tomorrow at 5 o'clock for the fiscal committees. And then, we're just looking straight into budget negotiations. And that's kind of where all the bills right now, everything, whether it's policy or a fiscal bill, funding, whatever it is, seems like they're positioning everything right now in rules or sitting in, on exec in the committee. And what we're doing, we're going to get past this cutoff here on Wednesday, and then they're going to start going at it with negotiations and try to come together on a budget. Realistically, where they're going to have the biggest problem is how they're going to raise money and where that money's going to come from, and exactly how it's going to be locked into. The note this year, a lot of times in the legislature, what they're trying to do, because they've realized that a lot of these funds, whether it's the county assistance funds or name it, any of these funds that seem to be making money in our revolving fund get swept over. So part of what they're trying to do is a lot of this new revenue they're bringing into these programs that they know are self-sustaining. They're trying to keep the money there. And so what it's looking like right now is the Democrats do have enough of a majority in both the House and the Senate. If everybody's on board, they can pass whatever they want. So in the Senate, they've got at least 3 holdouts who don't like the revenue package. And in the House, they have probably 4 or 5 that they're going to have to really convince. And so that's the infighting we're seeing is inside the D's party.
And in the House, they have to have at least one Republican to pass the new taxes.
Yep. And so they're going to have to convince their swing votes in the Senate, and then they're going to have to bring somebody or several somebodies across the aisle in the House. And that is going to be the biggest challenge. And as they start coming together on these things, once they resolve an issue in the budget, they're going to pass it out of the, respective houses and move on. So they're building it as they go right now. And they're including, they're even holding back policy right now as bargaining chips. And it is really strange this year. Senator Hobbs on the transportation side of things, it's pretty controversial how and where he wants to source the funding, but like we've been saying, he wants to keep the funding in the transportation budget and make sure that people can't steal it. So there are positives and negatives there, but I think long story short, we're looking at definitely more taxes. One of the things that we're, all over the place right now in terms of taxing is that REIT tax. And they're still not finished with that, and they're going back and forth on that thing, trying to figure out exactly what houses and what properties are going to be taxed. One of the things that happens in the rural areas that we're hitting on is there's not a lot of houses or estates, above that $1 million, $2 million, $5 million mark. And what, in the last version we had, they're basically putting a minimal REIT tax on anything under $250,000, which is a majority of the houses that are going to be sold in the rural areas. So it was really interesting. Last Thursday, we were at our county scheduling meeting, and they passed around a list that WASAC put together that said, here's all the losers in the current REIT plan. And by golly, it was our client list. So the rural areas are getting hit pretty hard right now, and we're trying to make that point. And it's, I don't know, falling on deaf ears as much as the other stuff that we're talking about, but, there's a long ways to go. One of the topics that we've talked about here a lot this week with the rural counties, WASAC has done a fantastic job this year in narrowing its focus. And by that, I mean they picked 5 topic areas, indigent defense, PILF funding, REIT, things like that are really big deals for the counties. And they focused on that. And it's been relatively effective. We are making an impact, and it's a unified front. But next year, and I think the conversation over the interim here really needs to be, how do we make counties a priority to the legislators? Because the money's there. The money's there for indigent defense. The money's there for all the programs that we have. They're just not prioritizing it to the counties. And so I think that's the next step that we really need to talk about, is how do we get on the top of that list and actually make the legislators understand, or help them to understand, anytime they pass any bill that requires us to do something that costs us money. And I don't know about you guys, but I'm going to take a stab in the dark and say that you're not down to, okay, these programs in your budget are non-essential, so we'll cut them out. I mean, that time is long gone. And so it seems like where everybody is right now is, okay, everything we have is essential. Where can we cut something and try and get by? And that's pretty much the county story right now. And so we've got to get past that. So, do you guys have any specific questions for us after that little rambling response I gave you?
Well, Zach, I have the answer to your question about how do we get the legislature to stop doing this with respect to the counties. It's real simple. It's real simple. We just point to the Constitution and say, look, it says you can't do this, and so we're going to stop doing these functions. Because it violates. Listen, it violates the Constitution. We've had this conversation for the last 10 years that I've been here, and the reality is that the legislature knows full well that they're violating the Constitution, and they also know that there's no repercussions to them for doing that. So the answer to your question is, what's going to wake them up and cause them to stop doing this? Nothing, until we, the counties, en masse, say we're not going to do this anymore. We're going to stop providing indigent defense. We're going to stop providing this. We're not unwilling to provide it. We're only going to provide it to the extent that you fund it. That's the only way this changes. You know that.
provide indigent defense for 3 weeks out of the year.
Yeah, and just
Yeah.
give them a heads up that we're gonna do it until the money they provide runs out, and when it does, we're done.
Yep.
'Cause
I agree completely. That is the answer. Problem is getting enough of the counties to get on board with that and do it. And for some reason, most of the counties seem afraid of the legislature. Afraid of something, they won't do it.
I'm guessing Franklin's not too intimidated by them. I guess we'll see.
I'm gathering that. But that's really where we are right now. And I mean, it really does need to be the topic of conversation here because, we really, like I said, we narrowed the focus and the legislators are aware of our problem. They just don't care.
If the Constitution if the Constitution is not enough to get them to do the right thing, and the threat of litigation from Wasatch, from the 38 or 39 counties, is not enough to get them to do the right thing, I don't know what options are left. It's, just going down this path because you asked the question, what do we do? I think that's the answer.
Yeah. Well, and I mean, I think, you've got the nuclear option there if you get everybody on board, really it's going to come down to McCleary-type lawsuit. Saying it'll go straight to the Supreme Court. It'll be because you're violating the Constitution and, Supreme Court will have to make a decision on it. And not a fast process, but it's probably going to have to happen.
Well, I'm not talking about litigation. I'm talking about putting in our budget all the funds that are provided by the state for indigent defense and announcing ahead of time to them that when those funds run out, we're going to be standing by prepared to continue providing those services as they are funded as required by the Constitution from the legislature. And I suspect what will happen is the courts will come in, they'll slap an injunction and tell us we have to continue to do it, but that's what will force it into court. And then the Supreme Court can decide if the Constitution says what it says. Anyway, I'll get off my soapbox, but I've been hearing the same question for a decade and hoping people are hearing the answer.
Yep, it's about time something happens, and that's okay. We've been hearing the same conversation and, sounds like people are finally getting serious about it now. This is where we're going to end up. So.
You also made the comment earlier that 5 p.m. tomorrow is the fiscal committee's cutoff and that all those bills have got to be handled. I know you meant to say this, but that applies except to any bills or NTIB necessary to implement the budget, which is anything they want to hang a fiscal note on.
And you are absolutely correct, and I'll extend that saying that even policy bills, if they deem them necessary to implement the budget, whether it has a fiscal note or not, they can deem any bill that way, and then it's still alive. So
the cutoffs only apply to the people who don't chair committees.
Pretty much. Yeah, they're more of a suggestion these days, and we've had a lot of conversation about that, up here. It's very, very interesting. They've got the rules that they're supposed to have and adhere to, and they just don't seem to do that very much anymore. They're just suggestions and kind of make people feel good and move things along. And on that note, it's kind of looking like, I guess it's 50-50 whether we're going to have a special session or not. It sounds like we hear it from a lot of the LAs, and they usually have a pretty good inside track on it. And they said, usually when there's going to be a special session, we're starting to hear about it now. They're preparing for it and all that. And in general, from the legislative aides, we're not hearing that they're being told that there's a special session coming. That doesn't mean that there won't be, but at least at this point in the session, they're not planning on it.
But on the other hand, the security is telling me that there probably will be. And they're kind of in the know as well.
So there probably maybe might not be some sort of a special session. So it's really what it comes down to on that is if the Democrats can get everybody in the same boat. And, that's really what we're looking at. And there's no excuse. If they have to go into a special session, there's really not any year, but especially not this year when they've got folks to do what they need to do. So, they're looking at it. That's the other point of contention there. The extra $5 billion in revenue that they're going to have to pass to be able to get everything done in the budget that they want to get done is kind of unreasonable when we have the largest revenue forecast this state's ever seen. And I think that's kind of the point of contention there in both houses, amongst the holdouts. They're going, well, this doesn't seem fiscally responsible, which is a very gross understatement.
So, Zach, some of the people I talked to yesterday suggested that an additional session might simply be a maneuver to buy time to find those additional votes to support a tax increase. Have you heard that?
Well, that's what it would be about, because that's the only way they can get out of here, to get those extra votes.
Yeah, and that's why we're seeing, a lot of what they've done is taken a lot of those policy bills and just put them on rural second reading, and then they'll hear them when they need to, but they're positioning all these bills to be able to pull them to get those votes. And so it is crazy right now. There's people running around. All we can do is count votes, and we have to count 4 or 5 times a day just to figure out where they are in negotiation, try and get things through. So yes, that is very correct.
The Senate wasn't able to pass the bond bill to fund the capital budget yesterday.
But yeah, that was their first shot at it. So, the back of the drawing board, we're going to see how that comes around, and hard to say,
Are you coming over this week, Brad?
Yeah, I'll be over tomorrow. I've got a Columbia Basin Development League meeting, and then I'll leave from there and get over there late tomorrow.
Okay, well, we'll be here in time to go to the reception.
Depends on traffic, Jim. I'll call you on the way and let you know how it looks.
Okay. Yeah, this will be the last reception that we have with the legislators.
And we should have, being that it's cut off and, they're supposedly wrapping up, we should have a good number of representatives. I don't know about the senators, though. So,
Gentlemen,
that we're running fine. Do you guys have any last thoughts or questions for us?
yes, I do. This is Clint Didier.
Okay.
On March 26th, we talked to you, and we talked about the gun bills, House Bill 1739, 1225, 1465, Senate Bill 5434, and 5508. How are we doing on those?
Those ones are pretty much in the same position as everything else. They're getting ready to move them. They're going to start doing floor action on things here in the next week. And it's really hard to say at this point what we're really looking at with those, because like many other things, they are bargaining chips.
Okay.
And that's where 98% of the bills out there are right now, is their bargaining chips. The ones they really wanted, they already passed. And so, obviously, all the rural areas, all of our clients are opposed to any of the firearms legislation, much like you guys. And right now, that's just like everything else. That's as much as we can do. We let them know and, hope that we don't get caught up in negotiations and railroaded by something.
So were any of those bills that we talked about, have they passed? We're talking about the vehicles, Senate Bill 5883, the Veterans Assistant Levies, 1829, 5947.
I'm going to have to look again this morning. I can shoot you an email with those ones that you listed on there and give you a report on those specifically so you know exactly where they are. I know that the Veterans Assistance Levies and the also Representative Maycumber's bill are probably going to pass, unless, of course, somebody does something and, pisses off the wrong person. So, but yeah, I can shoot you a rundown on those and then kind of look into them a little bit more closely and give you some predictions on them if you'd like.
Okay, thank you.
One more before you go. Yesterday afternoon, the Senate, one of the subcommittees, is supposed to talk about this excise tax on capital gains.
Okay.
Did you get into
I believe they talked about it, but they did not exec that bill.
They did not. Okay.
There's a big list of exec today and tomorrow. Today and tomorrow they're pretty much all executive session, and they're going over those, and they're in and out of caucus. They're taking caucus breaks every few minutes.
Okay.
So, And so where we are on that stuff, the last little note from us here, pretty much everything from now on is behind closed doors. They're making decisions and doing negotiations, and that makes it really difficult unless somebody is going to break ranks and tell us, kind of under the table what's going on. It's like crying teeth to figure out what's going on.
Yeah.
So it's all negotiation and tit for tat, and that's kind of where we are.
Well, thanks for your help.
Absolutely. Well, thank you guys very much. We appreciate it, and we'll move on to the next one.
All right.
Thank you.
Thank you.
Bye.
Bye. All right. We have one set of minutes here from March 26th. If there's no additions or changes, I'll sign them. Okay. Then we got Matt, please. We got public hearing on repealing and replacing section 10.08.
Great. Thank you, Mr. Chairman. Actually, if it pleases the board, I'm going to turn this over to Craig Erdman, the county engineer.
Okay.
Yes, we're here for the public hearing today in regards to the proposed changes to the speed limit ordinance. On August 6, 2014, the board passed ordinance 4-2014, which set speed limits in Franklin County with regard to RCW 46.61.400. And the ordinance was codified in the Franklin County Code under Chapter 10.08 and has been in effect since. Public Works Department has drafted an ordinance that will repeal the current ordinance and replace it with a new ordinance that reflects changes that have occurred since, and with the additions of new roads and removal of annexed roads. Also, the Public Works Department has determined through engineering and traffic investigation at the discretion of the board that the following roads and streets warrant changes to portions of their current posted speed limits. That list includes Court Street West, Dent Road, Fanning Road, Glade North Road, Kohler Road, Palouse Falls Road, R170, Road 68, East Vineyard Drive, and West Sagemore Road, as shown in our packet.
The only thing I would want to add is as part of the board's submittal for your review, we included the draft ordinance. In the future, we look to change how we do this so that the board could effectively see all of the changes. Unfortunately, we didn't capture all the changes, so what we tried to do here was highlight those roads that Craig listed that we're looking at changing the posted speed limit from what the statutes dictate. But in the future, of course, we'll do everything to provide the board with a copy that reflects all of the changes that we make. So I want to apologize for that, and hopefully what you have will make sense to the board.
Well, this is time for a public hearing, so I'll open the public hearing. Does anybody have any pros or cons on the replacement of Section 1008 of the code? Hearing none. Commissioners?
Well, I think we're going to have a problem with Glade Road. That's going to be a tough one. I think the sheriff's going to be pretty busy on that stretch right there. How well are you going to mark that 45-mile-an-hour zone? Are you going to put a blinking light up? Because that's the only avenue now north besides 395. And this morning coming in, it was car after car.
Yes, it is our intent later on, when budget allows, to put in flashing speed signs for that.
Because there's going to be a lot of people that are unaware. If you just put up a 45-mile-an-hour speed limit sign, they're not going to see it.
Yeah. And
there's a lot of building going on around there. The Allied Potato Company has put in 3 storages in a warehouse there, and then we've got across the street, we got another storage. But we have the same thing up north. I mean, we've got 3 storages right there from Sagemore to Cedar. And it gets really heavy there, too, when we're putting potatoes in those storages. I own one of them. I know. Yeah. But we don't slow it down there. And to slow it down on the main artery going out there, you're going to have some people upset. I'm going to tell you right now. And I thought there would be more in here. I posted this.
Yeah.
But obviously everybody's busy right now. The weather is broke. The last 2 days have been rainy, and I just sent Craig, some pictures of North Bellevue, North Cooley, and Hope Valley. It's so mucked up they can't even get trucks down the road. The gravel's gone. From
that piece of Glade North right there, South Landing, is a blind spot.
It is.
It's people coming south wanting to turn east is just, it just almost feels like Russian roulette going up there. But you're right as far as getting the signage up there to get people to be aware of slowing down.
What's the distance there again? Is it 2-3 miles? It's a little over 2 miles.
Yeah.
Yeah, it's from milepost 2.95 to milepost 4.7.
Just short of 2 miles.
So a little bit under.
It's important to note that, with a lot of this, not just the traffic investigation, the geometrics, but also zoning, some of the other areas are listed, or some still may be agricultural zoning. This area here is actually zoned industrial, and we only see that industrial usage growing. So it's really our speed ordinance catching up in some cases with the zoning, very similar to some of the changes that you see that we're recommending in Dent and Kohler, where the zoning is changed in those areas from AP 20 to residential type zoning, and really just trying to be consistent with the zoning as well. So we understand any changes will be an impact to the traveling public, and of course when we change anything, there's some guidelines on what we can do to make it more visible to the people, and then through that we'll continue, Craig and his staff will continue their engineering studies, and we go from there, and that includes speed studies, traffic studies, and then we as Craig said, as funding becomes available, we try to implement other means to really create the most, the safest environment out there. So, yeah.
So, Matt, as you go around setting these speed limits, you and Craig sit down over lunch and you just kind of throw darts and you say, yeah, that should be 20, that should be 40. That's how this works, right? Because none of this is tied to state requirements or zoning requirements.
Zoning, geometrics of the roadway.
Okay, that was intended as humor. The point is, every one of these changes is tied to a specific state, site distance, traffic ADT, zoning. None of these are what you'd call, or what could be described as purely discretionary. They're all tied to a specific statutory or WAC obligation or DOT obligation.
Yeah, or just engineering principle. I would point.
Okay, so talk more about that, if you
would,
please.
We have certain criteria for like site distance and things like that. Not all those are codified, but they are general practice, good practice.
Okay.
And we try to keep to that level, that standard, and level of service.
So you call those accepted engineering practices in use throughout the state?
I would say so, yes.
Would that be an accurate way to say it?
Mm-hmm.
Okay.
So long term, what are you going to look at doing in that industrial site? Because down towards Pasco, where Tater Boy, which is now Lamb Weston, 4 lanes, turn lane.
Yes,
are you going to do that through there?
That is in the area that in our future transportation plans we want to see move to an all-weather system, and there we could address those issues of widening and making turn lanes perhaps. That would be part of our investigation when we bring the project up.
Now, we have it all-weather to self-landing, correct?
Correct.
Yes.
Yeah.
But from self-landing on up.
Yeah, but from self-landing on up there's just a couple turns. Right there at self-landing is where a lot of the traffic comes in, and then south of self-landing is where all this construction is taking place. So that is the key area from self-landing. You've already got the all-weather road. So we should be looking at making that into an industrial roadway there instead of...
Yeah, to be honest with you, it's we don't want to give the impression that we're throwing anybody under the bus, but certainly past administration and the Public Works Department, when that section from Clark Road up to South Landing specifically was converted to an all-weather road system, it was reconstructed. I'm not sure why that wasn't done at that time, ensuring that there was the appropriate turn lanes. It was zoned industrial at that time as well. So you bring up a good point. These are things that Craig and myself, now that we are the administrative team at the Public Works Department, are looking at, and certainly we want to affect those types of changes as we move forward. And so certainly we were discussing that specific thing probably last week about left turn lanes in that area, and looking at whether or not we should be putting in right turn lanes, right turn tapers, looking at those types of warrants. We always look at warrants where it's warranted. So you bring up a very valid point, and certainly these are areas that we're looking at and we're trying to definitely improve upon as we move forward on behalf of the board. So
predate these two gentlemen.
Yeah, unfortunately, in some cases, we just wish there might have been a little bit more foresight, a little bit more planning. That's really...
I think out of the six of us, Commissioner Cook was saying he's the only one that was here then.
No, we don't. Certainly, it's our job to bring forth to the board the best information for your review and concurrence for us to move forward. So, but yeah, there are areas that certainly all of you can identify and that we've identified that we just look back and go, why didn't this happen? It would have been more economical to take care of it at the time that it is going to be moving forward, especially with where construction prices are now compared to where they were 10, 15, 20 years ago.
So I'm looking here for a date when this is going to take effect.
Usually, let me get to that. For us, this would take effect, and it would give us our marching order. So once the board signs it, we would go out and get these changed. And so effectively, once those new signs go up, that's the day of effective change.
Can I request that when the signs go up on Glade Road that we make them a blinking traffic light at that time? Because otherwise we're going to have to get some leniency from our sheriff's department to the fact that a lot of my neighbors out there that are running parts and are in a big hurry are not going to know that has been lowered by a sign. And they are going to be getting ticketed, and I won't be the only one hearing about it.
So Matt, real quick, couple of observations. Previous experience tells me that the traveling public pays almost as much attention to what they feel is a safe limit for that stretch of road as they do to the signage. So we can expect that, as Commissioner Didier says, not only will they be driving faster than posted because they haven't seen the change yet, but also because they've got a long-standing practice of believing that 60 is safe there. Mm-hmm. And certainly wouldn't begin to speak for the sheriff, but my guess is that they would probably start out giving people some advice and some warnings before they started ticketing them. Yeah. And as for Mr. Didier's question about flashing lights and stuff, is that a significant increase in cost to do that? And is that something that we would normally do, or can you put a temporary flashing light? It doesn't seem like it's appropriate as a permanent speed limit sign to have flashing lights, but for temporary during the transition, maybe that does make sense. What do you think?
Well, typically the signs we'd have in mind are the radar signs that will give you your actual speed. We found those to be the most effective in educating the public and getting their attention.
So use that as an interim measure?
Well, for as long as they would be effective, would be, what I would propose. I mean, they are movable. We can pick them up and take them to other places. Another thing we could look at, we could rent a speed trailer with signs on it that warns people that, until they get used to this, that, we have a 45. That might be a lower cost. When we looked at it, we thought it'd probably be more effective to put the permanent radar signs up at least for a few years to get that. The cost for those, though, runs, it would be about $10,000 to $15,000 to place those additional to put those two signs in.
Is that similar to what you have when you're south on 395 and you're exiting west on 182?
Yeah.
Okay.
I'm just going to ask the question for clarification. Is that what's planned today, is to put those variable speed
Yes,
signs up?
at a time when we had funding to do that.
But until you have funding, what's the plan?
Then we would put up the normal 45-mile-an-hour speed sign, put up a traffic revision ahead sign, flag it up, put it on our website, get it to, maybe advertise in the newspaper or whatever, just to get people's attention. But we would do more than just put up the 45-mile-an-hour speed limit sign. We would let them know that there is a revision ahead.
Didn't you have a speed trailer at one time?
Yes, I think that
was that sheriff's department.
I think it was ours, but I think it kind
we
of
had one that was not functioning, as I recall. It was not reading reliably.
Yeah. So we've been talking about replacing it eventually too, but we could look at renting one in the short term.
Yeah.
So your long-term plan is to put one that is a radar sign?
Yeah. Been my experience so far that those have been effective.
If that's the long-term plan, Matt, would you not do that initially? Is there some reason why you wouldn't do that from the start?
It's just cost. Like I said, we've been fortunate enough in the past to get the federal funding to pay for those signs without any local match. And
we just did a package on those recently.
Yes. And so,
do you have any more of those federal funds available?
Yes, we're in a call for projects right now, so we'll have that out to the state at the end of May, I believe.
I'm guessing if we pre-fund it, then getting reimbursed is not an option.
No.
All right. No further questions. We do have a ordinance in front of us, 01-2019.
Mr. Chairman, just a minor point of procedure. I think we've opened a public hearing. I don't think we've closed it.
I thought I'd closed it before I opened it to the commissioners,
well,
but I'll close it again.
But I didn't. If you did, I didn't catch it.
As I said, I'll close it again.
Okay. Mr. Chairman, not hearing any other comments or questions, move for approval of Ordinance 01-2019 with discussion.
No second?
I'll second.
Discussion?
Mr. Chairman, this has been recommended by our professional engineer and Public Works Department staff. They've assured us that all of these are compliant with standard engineering practices, state administrative code, DOT guidelines, etc., and that none of these are deemed to be just discretionary or somebody's opinion. But I think it's important, given the likely impact of these changes on our motoring public, that we have a unanimous vote by the board, and if there's any concerns about approval of this, I would hope to hear those before we vote.
We have a motion and a second.
I do have concerns about Glade Road and the unwarranted ticketing of our patrons up north. So I just hope that if this happens, I just hope that you realize the hornet's nest that's going to be flying in here.
So, Mr. Chairman, since we're in discussion and there's no prohibition I'm aware of to broadening that discussion beyond the board, I would just ask the sheriff if he's got any thoughts about interim enforcement measures that would respect the fact that the motoring public will be surprised in some cases by the signage change.
Well, there won't be any unwarranted ticketing. We'll go through an education process if the speed limits are changed, and we'll give everybody ample opportunity to comply. But, of course, once the ticket's written, that's up to the courts to decide. That's always our last approach. So it sounds to me like we need to probably explore some grants or something to get a couple radar trailers that are modern and digital so that we're able to move them about. That probably is a better use of $15,000. I don't even know what one costs nowadays.
Yeah.
In the interim, I just sent a text message to someone past us, see if we could borrow one or two of their trailers for a while to educate on that. Pretty sure the answer would be yes. We'll at least get one. We'll go from there. But it sounds like we probably come time that the county needs to get themselves a couple traffic control devices that are mobile.
Thank you for...
Most days, just so you know, we don't have a fleet of cars working traffic. So as of today, we have 2 people that are working the entire county at 1,300 square miles. So there's not a lot of time to set up radar traps, for lack of better words, around here. So we'll work through it.
One other question is, this morning we had a state trooper, commercial vehicle state trooper up at Merrill's Corner in a black pickup with no exempt license plates, no distinguishing marks of being a state trooper. So they're working Glade Road too. With this implementation, they are justified in giving tickets also, correct? Are we going to be able to notify them?
What kind of tickets? Actually,
speeding tickets.
State troopers, as in weights and measures? Because
well,
they're not.
That's what was up at the corner this morning. Well, but we have seen state trooper cars running Glade Road
so
also.
It's a rural state route, Glade.
Exactly.
And state patrol can work that if they choose. They
right.
don't generally work it that much. But what you're seeing is weights and measures, which is, that's done all the time in rural Franklin County. They'll check weights of trucks or those type of things and enforce those weights and measures laws. Is completely a different thing. They don't have authority to write people speeding tickets or those type of things. Strictly weights and measures.
Yeah, I'm pretty familiar with them through the years.
Bet you are. All right.
So, but I'm just saying that the state troopers also will have that authority. And so do we let them know also? Can you do that? Or who does? That we're going to be doing a speed change and that we're going to be a little bit lenient with the public for a while.
No. No.
Can't get a hold of them, let them know.
I can pass it on, but we're not going to tell the state patrol who they can write tickets to or not write tickets to.
Well, our state's looking for funds all the time, so I imagine they'll be hanging around there like a bunch of vultures.
We'll get it taken care of. I don't think there'll be a whole lot of problems with it. We'll get it figured out.
No further questions? All in favor?
Aye.
Aye. Aye. So, thank you.
Great. Thank you for your time.
Thank you.
Thank you, guys. We'll move on to a closed record hearing. Nicole?
Good morning, Commissioners. Thank you, Mr. Chairman. What we have before you today is a conditional use permit. It's file number CUP 2019-02, and this is a closed record hearing on the application to renew an expiring conditional use permit. Before I begin, however, I did want to give an opportunity for any disclosures or recusals, since this is a quasi-judicial matter.
I have no associations, connections with any of the parties or the property, so nothing to report.
No, I have nothing.
Okay, great. Thank you. So the approval of the CUP would allow the continued operation of a 100-acre gravel pit site. It's located in Section 19 of Township 13 North, Range 31 East. That is about 1.5 miles northeast of the city of Mesa, near Burlington Northern Tracks, and it's near Poe Road and SR 17. We processed this application. We've coordinated for agency comments and reviewed the application in conformance with the Franklin County Code. We advertised to the public via adopted public notification procedures, and we contacted agencies for review and comment. This also went through SEPA, and a SEPA MDNS was issued with 4 mitigation measures. I want to clarify that we did notify everyone within 1 mile of the site. There was a mistake in the staff report that said it was within 500 feet, but in fact we did notify everyone within 1 mile, which is our practice when there's a location.
Anybody?
What's that?
Did you find anybody?
Yeah, there's a couple addresses. And that's our practice when we're outside of an urban growth area.
Excuse me, isn't it a notification not for people living there, but for adjacent properties within a mile?
So there's property owners.
Yes, it's the property owner's record that we use.
So, well, just for my own clarification, if there's a property boundary that's inside of a mile, even if no one's living on it, you still notify that property owner, right?
Absolutely.
Right, okay.
Yeah, and that includes many times we send it to federal government.
I appreciate the humor of the chairman's remark, and I get it, and it's funny, but I didn't want people to think that a residence was necessary for notification. It's just an adjacent property.
That is correct. And just for further clarification, we don't know if someone's leasing or residing in an area. It's the owner of record, according to the assessor's records.
Yeah.
We provided a recommendation to the Planning Commission for approval of this application. The Planning Commission did meet on March 5th with a duly advertised public hearing, and they unanimously passed a motion 5-0 to put forward a recommendation to you with 6 suggested findings of fact and 17 recommended conditions of approval for this. Just by way of background, this is a site that's been operated for the past 15 years via a previous conditional use permit. It's due to expire. The actual expiration was February 2019, but an administrative extension was granted through August 2019 or until a new CUP comes into place. And they've been operating the site under that previous conditional use permit. One thing that was important about this review is that in the intervening time, the county does have some new codes in place. Most significantly, the critical areas ordinance has been updated. So our review had to look at the environmental factors in critical areas and our regulations that have been adopted since that time. So there's a little bit of change with that. I also wanted to highlight that in many cases we've defaulted to other agencies for some of their regulations. So the Department of Ecology, Department of Natural Resources, and Department of Fish and Wildlife will all be involved through the permitting process of this site, and they'll have to provide to our department copies of all the items that they get issued from those agencies. And that will cover a lot of things that maybe aren't covered in our code that are still important for safety and environmental stewardship and welfare out at the site. One thing that we looked at is just that critical areas review. So the site where they're mining is in close proximity to a pond. Pond used to be used by the public as a fishing pond. It's no longer in that use, of course, but it's still a critical area.
Excuse me.
Yes.
I need some clarification on that point.
Yes.
It used to be owned by Burlington Northern Railroad, and it was stocked with fish by Washington Department of Fish and Wildlife, and it was known and recognized as a local fishing pond.
Right.
It may not have that official designation anymore, but your statement was that it's no longer used in that fashion. How do we know that?
It's no longer advertised for that use. I did check the Department of Fish and Wildlife pages and also DNR, and it's not listed, Rio Loop Hunt. And I've talked to those agencies.
So recognizing it doesn't have any official standing, I'm just wondering if, because of a previous long-standing practice of using it that way, if people still fish there. And Commissioner Didier lives up that way. Perhaps you have some insight. You know if it's still used by anybody for fishing or recreation.
I don't. I just know that it was very heavily fished at one time.
Okay.
But I don't know at this time if anybody's. I'm sure there are people going out and trying to
It
fish.
depends upon if they've gated the coulee or not.
And I certainly don't know about the use, but I do know that the ownership has changed hands and that the practice of stocking the pond is discontinued.
Yeah. And I don't want to get us off track, so I'll hold my other questions and come back around to this point because I think there's some other issues associated.
Yeah. So the pond is a critical area, so we wanted to make sure that that's appropriately addressed, and so we put some measures in place with those conditions to address that. The other thing I wanted to emphasize is this would be in place for 15 years' time. We had a little discussion about that with the Planning Commission. We feel that 15 years is an appropriate amount of time. It certainly matches what was approved before. If they, for some, we don't know if they're going to want to, how long they're going to use the site for mining, but if they did want to continue the CUP in the future, that 15-year horizon helps to sort of link in with how we do our comprehensive plan updates. It would seem sort of inappropriate to give them a conditional use permit that would extend beyond the life of the comprehensive plan. And also that allows for revisiting for things that come up, such as what we've experienced, changes to our codes and ordinances, so that they can go through that re-review. So the action for you today is, unless you, by a majority vote, deem that further review is necessary, you would effect, by proper action of the board without further review, put this into action based on what the Planning Commission has recommended. If you feel that further review is necessary, we would need to conduct a closed record appeal hearing, and we would need to give notice of that, and we could come back to you on April 30th in that case. So with that, I'll answer any questions that you have.
Well, this is a closed record hearing, so commissioners, do you have any further questions?
Mr. Chairman, I've got several, but I'll defer in hopes that some of mine might get answered and I don't have to dominate the conversation.
I don't have any questions. I know the site.
I know the site too. This was Weinberger had this at one time and made railroad rock that we use for stack yards, correct?
I don't know the answer to that.
Yeah, the original. We reference it more as Bennett because that's the current owner.
Yeah.
Okay.
Bennett owns the property, and
Weinberger
was leasing buying the material from him.
Yep.
So, Derek, you and I spoke yesterday. We covered a lot of ground. Thankfully, it'll save us a lot of time today. I wanted to get some clarification on a couple of things, though. This application is for a new permit, not an extension, because there's already been one extension granted. It was done administratively. My question is, and this is not necessarily a direct concern about what's been done, but for future understanding, where is and what is the authority for an administrative extension? Normally, I would imagine an extension for something of this nature would come back to the same body that approved the permit in the first place. The nature of an administrative extension, however, sometimes is different, like with short plats. I know it is. So do you know, is that authority embedded in county code or state law, or where that comes from?
It's off of county code regarding an extension of a conditional use permit.
Okay, so the county code gives you, as the planning director, the authority to do that extension without consulting the board?
Correct.
Okay, that was the question.
And
thank you.
That's why it's termed.
Did the current permit, well, actually there is no permit now because it expired at the end of March, because there's a 30-day grace period after its closeout in the end of February. So right now we don't have a permit. And just kind of a curiosity, why was an administrative extension needed? My understanding is that they contacted us back late last year saying that they wanted to renew the permit.
Their initial contact was to determine whether or not a renewal was going to be necessary or whether or not there was an administrative option. The response was that we can perform an administrative extension up to 6 months. If the activity was going to continue beyond that, they would need to resubmit for a new conditional use permit. At the time, so there was a little, that was, if I recall correctly, back in October was when that initial contact was made.
And then they gave us an actual notice early in January, right?
Correct. Through the submittal of the CUP application, it's kind of a prima facie request for the extension to cover. So the terms continue forward under the old one until we establish the new conditions, if any, through the new CUP, the new conditional use permit.
Okay, so let me interrupt you there because that's a good transition to my next question, which is the package allows for the rights and privileges to be transferred to another individual. It could be an heir, it could be an assign could be anyone. And is it your understanding that that is a statutory requirement? Is that a local option? Is that driven by the code? And so the basis for the question, to help you answer it, is that sometimes the operator of an activity matters to the board in these situations. And obviously we can't discriminate between operators based on certain non-merit factors, but sometimes there are merit-based factors where we might be concerned. And so what the question is, what is the driver for the package saying that the permittee could transfer this to another heir or assign, and does that have to come back through us?
Okay. The principle associated with the assignment of a conditional use permit allowance to a property is because that's the issue of a conditional use. It's about the use, not necessarily the ownership.
Okay.
So that's kind of the fundamental basis. Therefore, since it's about the use, under one ownership, the use, as long as it continues in the same way as the prior owner, should still be compatible, everything should be right. That said, specific conditions, and that's part of the conditional use permit, may require additional conditions or nuances such as a term. Quite often conditional use permits exist as long as that activity continues. However, under certain circumstances, for example, we believe as appropriate here, you term it out because there's rationale or reason that you need to do a recheck at some point, and that would come out in your findings of fact in that situation. It also can, depending on the specific nature of the conditional use required, it may be contingent on a specific individual to apply that use. Off the top of my head, I'm drawing a blank as an example. I don't know, maybe a music studio or a arts venue that's all based around a particular party. In that case, there may be opportunities or rationale for assigning it to an individual as well. So there is some local flexibility within the locals as to specific conditions.
There may also be some changes in practice that aren't articulated in here. For example, frequency of blasting of rock or other activities that are not anticipated that would be an abrupt change from a previous owner, which could bring about a variety of circumstances. So back to help us refocus on the question, if the person who receives the COP wishes to assign it to another individual, does that need to come back to this board for approval, or can they simply sign it over and it has the full force and effect through its existing term?
If I may, just to answer that as well as I can, the transferability would be something that would not come back to this board. It's something that they have to report back to the planning department. Should something occur where the actual use or activities or externalities that are experienced, the effects or impacts of the use, should those shift, we could look back at SEPA, we could look back at the original application and say, well, you're actually not doing what you originally applied for or disclosed that you'd be doing, and so actually you're not in concert with this conditional use permit.
So I appreciate that description because these conditional use permits are not very specific. They talk about a general nature of work and a practice, but within the specifics, you could have significant changes in practices and still not be outside the language of the conditional use permit. And that's what I'm kind of getting to is shouldn't this board have an opportunity to review and absent any significant merit-based change, it would be transferable. But the question that underlies all of this is the aspect of transferability a requirement of statute, or is it a county policy?
Okay.
Because if it's statutory, then I don't know that we have a lot to say. If it's a locally derived decision, then I think it ought to come back to this board.
And to answer that part, I'm going to go a little broader.
Okay.
So there is no statutory requirement or state law that says, yes, you have to make conditional use permits transferable. It is, however, a very common practice. And it's something that my firm recommends. And the reason is just from a broader perspective. A lot of times there are situations where someone is trying to get a property entitled for specific use, but they may not be the person who actually does the use in the future. Classic example is a developer trying to get something set up, and then a builder comes in, or someone else comes in to actually operate. And you probably would want to facilitate that to be able to happen for economic opportunities and different projects and things to actually take place. If you put too many limitations on that, you're really limiting opportunities out there. So in the broader perspective, it's good to have this transferability. But I hear your concern, and I would point back to the SEPA. I think that if things got out of hand or there were concerns, we could look at that, or we could look at the DNR-issued permit for the mining activities, things like that, which could be a trigger for re-review and bring it back to the board if there was an actual problem in the future with the CUP. I mean, if they don't match up with what's in here, and it's not just what's in the resolution, but the underlying SEPA analysis and MDNS decision and all of that, that can all be drawn back for re-review.
So right now they do intermittent mining, and they stockpile materials, they sell them as needed. Something changes, demand goes up, and now they're blasting twice a week, and they're crushing rock 7 days a week, and they triple the number of trucks coming and going. And the impacts to the surrounding property owners who said, I don't have an issue because I hardly know they're there. All of those things are still likely within the generic SEPA terms that I read in here.
Well, there's no discussion of rock blasting in the SEPA, so I think that...
Well, and that's kind of what I'm getting to, is that these documents are not specific enough in detail such that they would preclude a new operator from radically changing how they do business and still be within the terms of the SEPA. They blast now, I'm told, and they crush rock. So we can come back to that. That's one concern I have is the open-ended transferability. I think it ought to come back at least to the planning department, who can seek concurrence from the board, or it ought to come back to the board. And then we can talk in a minute about some of the reasons I think that's so important. I'll just give you a heads up now. It has to do with the fact that there is what I would call an open and notorious use history of that being a public fishing pond. And people are still going to go there and use it to recreate, to fish, and to do other things. Some people will bring their kids, then they'll be very closely watched, and they'll sit by the edge of the pond, and there's a buffer, and probably life is good. Some people will allow their kids to go climb on the hillside. And at some point, we've got a situation where we've got an activity that is outside the normal authorized activity in that zone. It's operating under a permit granted by this board, and there's no signage anywhere saying that this is a hazardous location. There is language in this package that we would ostensibly approve that says it's a known geological hazard area. And so the kids are playing there, and there's a rock fall, because remember, this is a quarry, and they're blasting occasionally, and rocks get loose. Rocks fall on kids, kids get hurt, whatever. It ends up being a joint and several liability issue for the county. So Am I saying that we ought to shut it all down and fence it and keep everybody out? No. But I do think that we have to mitigate the county's liability because the public has a use history there, and there's no signage warning of any hazard. There's no gate telling people it is private property. There's nothing there that would cause the general public not to think that it was, or not to believe that it was unsafe or that they shouldn't be there. So I'll just say that I think the package should include a requirement for the operator to have insurance to help indemnify the county's risk, and there ought to be some posting at least around the actual geological hazard that we've talked about in writing, cautioning people that this is a known geological hazard site, that it's private property, and there's no trespassing. If we fail to do that and people go down there to fish and their kids play and somebody gets hurt, we're going to end up in court and we're going to own 100% of the settlement that whoever the CUP owner is doesn't cover. That's just the nature. And I see Jen Johnson sitting in the back, and she's not waving her arms yet, telling me I'm off base. And do you have any concerns about what I've just described? Does that seem reasonable? Reasonable and accurate. That's better than I usually get, so I'll take that. So anyway, those are the three things that I want to make sure I address. One was I don't think the outright unimpeded transferability serves the county's interest. Somebody ought to look at it. Two, I think it ought to be posted to let people know that we think there's a geologic hazard because we put it in our own ordinance, so obviously we think so. And that'll be the document that gets held up in court saying the county knew that this was a hazardous area and it didn't even require anybody to put up a sign to let the public know. So insurance, posting, and transferability. Thanks.
Anything further on that?
Process question. Previously, I think we've been able to make additions and deletions. This is a closed record hearing, so we can only speak to what's in the record. Hopefully, we've done that. Is there within the permitting process, are we able to add some conditions of approval as I've just spoken to, or do you think we need to go to a closed record hearing and discuss adding those?
I would recommend going to the closed record appeal hearing, and that would also give staff time to work with legal advisors to get the language right and bring you a new resolution that would have those items. And then that would also give the applicant an opportunity to respond to that at the future meeting date. So as I said, we can advertise this to bring it back to you on April 30th. That would give us sufficient time to advertise for that.
All right. Well, those are just my views. I know the extension runs through late summer or fall, so I believe there's plenty of time to do this. But again, that's just my views. It'll take at least one other commissioner concurring that that's the right way to go. So that's my input.
Yeah, and if we were going to bring it back to you, you would need to it would need to be a majority vote to actually schedule a closed record appeal hearing.
One additional commissioner.
Yeah. I can agree with that.
Oh, yeah, it's a majority.
Yeah. Commissioner Didier, are you like-minded? Do you share these concerns?
Does the Heinen Brothers have a conditional use permit on their gravel pit?
I would have to double check, but my understanding is
It's right there in
much
Eltopia. I know they do blasting all the time, and they just got done blasting and making big piles of
I
rock.
presume that they do, but I don't know that for a fact. We'd have to
I'm
look
sure
at
they
files.
do. They would have to in order to do that, correct? Yes.
It depends on various things. Back in the day, it depends on how old the mine is and various actions like that. That's why I'm a little hesitant to respond one way or the other. I need to look at that specific file.
They just got done this last fall, and I don't know how many times they blasted, and they made all the rock. In fact, our county road department is using the rock. I don't see a problem with it. I know that it is common practice out there in the pits, but I make a lot of base with my 9, so we rattle the ground, but we don't blast. I really don't have a problem with this opening back up and using this pit. It should certainly help the people local to it for access to rock. So it's happened in the past. We never had a problem. and I really don't see a problem here.
So Derek, maybe you check for me and find out what the status is on the other activity.
The other,
the
other site?
Hyman Brothers
Yes.
site, right?
Yes.
We obviously want to give equitable treatment to all of our citizens, and it'd be interesting to know whether or not it's in a zone that even requires a CUP. This requires a CUP because it's in an ag zone, not an industrial zone. The other one that's cited might be an industrial zone, and therefore conditional use permit's not required at all.
And again, some of the activities or mines, depending on when they went in, the rules weren't the same, and as long as those continued forward, they were probably granted non-conforming grandfather status. That's why I wanted to go double check. Those things have back in the day, they were very loose. It's become much more tight nowadays, so I'll check and I'll provide that.
And some of the concerns, too, are the fishing pond, the historic fishing pond that's there.
Yeah, I don't know what the use level is today, but it's got the potential, certainly, and it appears that the only access in there from an emergency ingress-egress is that one road. And I know we've had concerns that it's cited in the package that it needs to be suitable for emergency vehicles to come and go. But oftentimes we'll have concerns about a site, and if there's a rangeland fire and there's only one way in and it's the same way out, then you've got a concern. I chose not to press on that point, but
I don't think that's a true story. There's an entrance to the north side near Connell also.
Up on the top of the hill?
No, in town, back behind Lamb Weston, but on the it's right below my house. There's a road that goes down, follows the tracks back down to that canyon.
So there's two ways in and out?
Yeah.
Oh, okay. Well, I appreciate that. I looked carefully at all the maps. I didn't see it, so you live there, you would know. And the last thing is I just wanted to ask Ms. Johnson if she wouldn't mind coming up for just a minute, because I need to ask an additional question. So you provide our civil legal advice, and part of your function is risk management for the county. And I want to make sure that I'm interpreting your feedback correctly. Do you think that would it be your advice, your legal advice, that the board not to move forward with this without getting the signage and insurance conditions that I mentioned, or would you be comfortable as our risk manager, legal advisor, endorsing moving forward without them?
As risk manager, I would suggest we wait for the signage and the insurance coverage.
And so your legal advice would be that we not proceed with a CUP without those?
I'm not going to provide legal advice in an open meeting, but risk management advice, I would suggest that we wait for those.
Okay. Do you have any concerns that you'd want to discuss about this in executive session?
We could do it that way, yes.
Well, do you feel a need? I mean,
I don't feel a need. I think you understand what I'm saying.
I do.
I would recommend, as risk manager, that we wait for insurance coverage and signage.
I just wanted to give you that opportunity in case there was something I wasn't thinking of in a legal context that you wanted to share. So I don't think we need one.
Anytime we can minimize our risk and pass any sort of
reasonable measures.
Reasonable measures. That's appreciated in the risk management area.
Yeah. Okay. Thank you. Mr. Chairman, I think that's it.
Okay. Well, we have a majority that asked for it to come back. Thank you.
So we're coming back.
Yep.
Okay.
And you comfortable that you captured the three issues?
We have it.
Yep.
All right.
Thank you.
Thank you, Mr. Chairman. Thank you, Commissioners.
Carly is up next, please. Morning.
Good morning. Thank you, Mr. Chairman. This morning, the first item I have for you is a request on behalf of the assessor, auditor, clerk, coroner, and treasurer. I have a resolution for you authorizing a 2.5% cost of living adjustment to their salaries for 2019, consistent with that of non-bargaining employees.
Questions? Everybody's had a chance to read ahead, I'm sure.
Carly, do you know offhand when the last time these salaries were adjusted?
January 1st, 2018.
Okay.
They received a 2% cost of living adjustment that the non-bargaining employees have received.
Okay. Yeah, the resolution does say that when it was set, and it was at 2% then.
Yeah.
Do you have a sense for how these salaries line up with what we call our comparable counties?
They're fairly in line. They're a little lower than our market counterparts, but as are all of ours.
We've discussed in the past our desire to kind of be in the middle third, because we think we have the capacity not to be in the bottom third, but we also recognize that there are counties with substantially more fiscal input than us, so we tend not to be in the top third. So we in the middle third on this one?
Elected officials' salaries are handled very differently by different counties. So
I understand.
It's more of a philosophical question than it is a comparator question. Some counties set the same for all elected officials across the board, including the commissioners. Others set different salaries for the different elected offices, and as I believe I've discussed with this board in the past, the question of elected official salaries is much more one of philosophy and politics than it is one of any contemporary compensation principles, which is why I generally am not in the business of making recommendations on elected official salaries, because it's not within...
I don't think I was asking that. I think I was asking how we align with comparable sized counties. And of course, the prosecuting attorney is a different dynamic because there's a statutory explanation there that sets the salary, at least most of it. There's some local discretion. So would you advise that, well, let me back up. Do you have an opinion that you're comfortable sharing in this setting with respect to whether we should just make all of the elected official salaries the same?
I don't have an opinion on that.
At this time? Okay.
Yes.
Well, that's fair, because you didn't know that question was coming.
No, I didn't.
Okay. Well, I did call yesterday. You were, I think, out sick.
I did leave early. I apologize for I missed your call.
No, not a problem. I just wouldn't have hit you with that here. I tried calling you ahead of time.
No, that's fair.
Okay. Mr. Chairman, no other questions.
So, Carly, we, on the recommendation, we have that the sheriff and the prosecuting attorney recommend approval. They both already received their COLA, correct?
The sheriff has, because his is set based on compression over the deputies and his command staff. The prosecuting attorney's salary is partially set by statute, and so it's on the stage, the cycle with the judges. I will be bringing you prosecuting attorney's salary change effective July 1st in the coming months.
Okay. And our assessor, auditor, clerk, coroner, and treasurer are the ones that are going to be affected by this?
Yes.
So how many, and this is a completely different subject, and I really don't want to tie the two of them together, because I believe we have an abuse in our benefits package, but I do believe that the COLA is warranted. I think that we need to keep our elected officials on par with the rest of the counties, and so I think that we need to really look at the abuses in our benefit package down the road here. So with that, I'm done.
Harley, the sheriff's salary is tied to a compression formula.
Yes.
Which is, I don't know how common that is elsewhere in the state, and I don't know that's particularly a concern here today, but is there a similar arrangement that should, I know it could, but that should be considered for the other electeds?
It could. Some
I know it could.
Some counties do it that way.
Right.
I don't have a recommendation on that at this time. But again, like I've said before, these are more philosophical and political decisions than they are.
I understand, but if these electeds aren't knocking on our door, there is some potential for this issue to get overlooked.
There is.
And so I'm just wondering if it wouldn't be more equitable for those other electeds for us to have some sort of a mechanism that any time the bargaining units represented in their office receive one, that it triggers a requirement for the board to consider one for the electeds. Doesn't mean we have to give one, but something to a mechanism there so that it doesn't get overlooked from time to time.
What I would, if I was going to make a recommendation, what I would recommend is that salaries are set for elected positions for the duration of the term as they are with the commissioner salaries. That's, if I ruled the world, that's what I would like to see happen, because I think then it takes, being as these salaries are not set based on compensation principles, they can tend to cloud the issue when it comes to salaries for non-bargaining or bargaining positions, particularly if you then base the elected salary off of those salaries.
So taking all personalities out of the equation and not talking about any electeds at Franklin County,
of course not.
You could inject a, albeit minor, but the potential for a conflict of interest where an elected would advocate for an increase because it increases their salary as well.
That is definitely a potential.
Or potentially does. Mm-hmm. And I suspect you're well aware that commissioner salaries are set the way they are before the term and are unchangeable during the term, specifically for the reason that you aren't leveraged one way or another in your decision making. Historically, commissioners in Franklin County have been pressured to return a portion of their salary for one reason or another, reductions in force, down economies, whatever they are. And we've tried to explain to people that that's why the statute is written the way it is to take salary negotiations completely off the table for the full term. And so your recommendation would be the same thing for the other electeds.
I think so, because I think some of those potentials, while they are not the ultimate decision makers for salaries, I think the influence and the potential for those same conflicts of interest are there.
Right.
Interesting concept.
Well, and absent those kinds of protections, in theory, I suppose you could have commissioners that express to judges a dissatisfaction with how they're ruling and how they're assigning consequences to people who have been convicted, and that midterm pay raise that they thought they were going to get isn't going to happen if they don't start getting tougher with criminals. That kind of theory and practice could happen, and that's why these are set at the beginning and unchangeable throughout. Okay. All right. Well, good discussion. Thanks for sharing your recommendations.
Of course.
Recommendation, singular.
Any further questions? We do have a resolution in front of us, 2019-104.
Mr. Chairman, move for approval of resolution 2019-104 as presented, and happy to have any discussion anyone wants to have.
I second.
Discussion? Hearing none, all in favor?
Aye.
Aye.
Thank you.
Okay, next up.
The second item for consideration would be kind of in the same vein. The county administrator's compensation package grants an eligibility for COLA increases consistent with those granted to non-bargaining employees. So this request, when I had approached the chair for some direction here, I know that Commissioner Peck, as we mentioned, I missed your call yesterday. But certainly the ASR says that the chair had directed, I think that...
he requested.
He requested, yes. Requested that I bring a request to the board for consideration of a COLA adjustment to the county administrator's salary consistent with that granted to non-bargaining employees and now elected officials. No other changes to the compensation package are being proposed. It's simply a 2.5% salary change.
Mr. Chair, I move for approval of Resolution 2019-105 as presented.
Mr. Chairman, I'd like to discuss this a little further.
Discussion?
Fiscal impact, $4,215 annual, $3,107 for 19. Is that going to be a combined $73.58, or is it just...
No. The annual total increase is $4,251 salaries and benefits, but because this would be effective today, the actual 2019 cost is $3,107 because there's no retroactivity.
$4,000 future.
Okay, so, but it says down below here that there was no COLA given in 17, correct?
There was a COLA given in 17, but not in 18.
Not in 18, okay. All right, so I guess on the back of the paper here, and I just was reading through this, the base salary of $138,580, and then we're making a matching contribution of up to 5% for annual salary. Annual performance evaluations. Have we had any evaluations?
We have not. The chairman has requested that I put together a performance evaluation form. We just discussed that yesterday. So I'll be working on that to bring to the board for the board to conduct a performance evaluation.
All right, because it doesn't matter who our administrator is. I think that it is important that we have evaluations if it's listed in here as one of the bullet points.
Yeah,
and then 6 months of salary and benefits severance package if employment is terminated. So if we have I'm not saying anything to you, Keith. It could be any administrator if he's caught in wrongdoing.
That's for termination without cause. If there is cause, then we're not. There's no.
If all of a sudden we decide that we need a new administrator, it would be all right. That would kick in.
So we are going to work on the performance evaluation then, and this will be the first in how many years?
He was hired in September of 2015. So
we haven't had one since 15, and we're supposed to have them annually.
So let's make a point of clarification. There's not a policy that requires them. During my years of term, Mr. Johnson and I met on a fairly regular basis, and I provided feedback on performance specifically as the chair. But I do agree that we need to have a policy that requires that feedback to be formalized into a written document and then added to the record for this purpose.
Well, under this resolution, it says annual performance evaluations. Annual means yearly, right?
Correct.
May include. So there's no obligation, and that's the purpose for having a policy now, I would say.
Then why do we list it as a bullet point unless name? Why do we even list it?
I think it was listed because it was what was initially offered when the position was offered, and it was a notice that it could include it. It didn't obligate that it include it. But I think it should. And
I do too.
And I think the policy that Carly's talking about is an appropriate change.
Well, and the other thing is do we have a performance schedule for our administrator? Do we put some goals in front of him, and what do we want to achieve? Because right now I'm looking out at our county and our county roads, and some of the other things that are happening in our county, and I think that our administrator is working hard at all this new stuff that's coming on board instead of putting our county first. And I want our county put first is my main important, because I'm hearing from the constituents up north, and I don't think that our county, as far as our roadways, as getting jobs completed, the bridge on 68, I don't think that we're getting things done in a orderly manner, and I would like to see it. And I'd like to see goals put forth about what we want to accomplish in Franklin County. And I can put forth what I want to see done, Keith, and I can give you that. And then also I've sent you a couple of emails. I've asked for the scheduling of all the veterans meetings, but I haven't received anything back yet. I was just curious of when I'm going to get that. About the meetings from the veterans, I sent you an email quite a while ago, and I haven't got it back yet, about just being updated for the meetings of the veterans, so that I would like to attend that. I'd like to participate in helping the veterans of our local area get this help that they need, because we do have quite a bit of money in that fund, and I'd like to see the veterans that are deserving start receiving that.
I'm not sure that they have scheduled all of those meetings, but
there presently aren't any scheduled, but I would refer the county administrator to the chair of the Veterans Advisory Board, and I'm sure he can find out when that is and share that information. I don't see that that's a problem in any way. With respect to feedback and evaluations and goals, they fit into a couple of different buckets, but with respect to performance feedback for the county executive or the county manager, county administrator, that's the term I'm looking for, that is not something that any one commissioner can or should do. It needs to be a board activity and discussion, and it is one of the reasons that the State Public Meetings Act allows for an exemption under the performance of a public official. So I think it'd be appropriate at a future meeting, and we can pick the date. We can do it quarterly, we can do it semi-annually, we can do it annually, whatever the board feels is appropriate. But it properly should be an executive session. The board members can discuss the county administrator's performance, and we can collectively decide on what ought to be included in the annual performance review. I don't know of another way to do it that is both lawful and equitable for all concerned. So I think that's the process we ought to use. But I'm interested in feedback from the rest of the board as to how they feel about it, and if they like that plan, how often we ought to do it.
Well, I'd like to also say that I've asked and requested that we have a nightly meeting, and of course the security issue keeps coming up, and I'm not talking about having it here. I'm talking about having it over track so we can have the public actually come in and participate in this also. Because right now you're not seeing very many people in our room because everything is busy, and I think that we need to have a nightly, quarterly meeting so that we can have the public more engaged on county business. This is something that I've requested twice. I believe this is the third time, and I'd really like to see us moving forward with a public nightly meeting to be held at the track facility so that the public can attend. We don't need security. I feel safe out in the public. I just want to start having the public more engaged. So with that, I have no more comments.
We would have to move the meeting date time to the track.
That would be fine.
It can't be a workshop with participants and involvement.
So
we still have a motion on the floor, waiting for a second.
I second.
Further discussion?
Mr. Chairman, I've got some additional comments on this general topic, but I'll hold them until after we vote. They're not necessary to this vote.
Okay. All in favor?
Aye.
Aye.
So with respect to meeting at track, meeting evenings, weekends, whatever, I think the record shows pretty plainly that I'm happy to meet whenever it's convenient for the parties. We do need to be sensitive to the cost that it incurs to have it off hours here with security. If we want to have all of our meetings over at the track in the evening, I'm fine with that too. I do agree that increasing public access to the meetings is a good thing. And like with every good idea, there are often unintended consequences. In this case, because we have different budget lines for track and for the county, we'll actually be renting space from the track. And to what extent and what that costs, I don't know off the top of my head, and I'm not suggesting that that's a barrier to keep us from doing it. I'm just pointing out that our auditor has been very steadfast in drawing the line between various activities, so it would be necessary for us to move funds between accounts to do that, I think. But happy to entertain meetings on different days, on evenings, on weekends, at the track, wherever it makes sense.
Well, I see our auditor in the room here. Mr. Beaton, would you kindly respond to that? What are we looking at as a cost?
I don't know.
Can you look into this and see?
Yeah,
because
we could ask them. It's pretty easy to do. Wouldn't take
do you
much
think
to
it's
put
going
it
to
off.
be a financial strap to us to
I
have a
don't think
meeting
so.
at track?
No, I don't think so at all. I think you talk to Tom French, and he's got a room out there, and he sets it up out into the future. And
he's got lots of rooms. Yeah.
Yeah.
I
think it's just a little bit of administrative work, but it's very doable.
That's something the public has been requesting, and so it was one of my goals to have a nightly, quarterly meeting, and I'd like to see it happen.
Do you think it's necessary for the current expense fund to rent that space from track?
Whatever the policy is, we'd have to look at what makes sense. For tracking, as an auditor, yeah. But not. It's no different than county owns the space. Well, we share it with the city. That's the issue, I think, there. And so, yeah, I think that's why I'm off the top of my head here, but I can look into it and get back to you on it. Okay.
So if I could.
There's our security.
So security for the courthouse is put in place under the courts. Okay?
Yes.
To open up and allow pass-throughs in the evening to this building and facility is totally in our control. There doesn't have to be security running people through. Then the sheriff's office would get accommodate that in some form of fast to get that all open. He did that with on-duty personnel. Shifting one of my commanding staff or making it happen. So the actual have to go through screening and all that stuff to have a public hearing in the county. It doesn't exist other than that. So that's the only way in and out. And so we can get around that.
Let me ask a question that comes from my military experience and having seen buildings blown up. If we don't screen people, what keeps them from bringing in a package and leaving it in a restroom adjacent to a courtroom, in a jury room, any number of places? Can we control the traffic flow enough to ensure that doesn't happen?
Yeah, I believe it.
Okay.
I believe we could help out at a sheriff's office level by sending over some corrections staff or some sheriff's office staff to make sure those things don't happen if you were told to leave it here without those additional. Council meetings go on all the time about all that security.
Sure.
And those types of things.
Yeah. Well, council meetings don't have courtrooms over there, and I think the judges in the courts are the ones that are most adamantly concerned. Okay.
We could be all for that.
There's no overtime costs with that?
We figure it out without.
Okay. Great.
Doesn't the planning commission meet here in this room?
Yeah.
Mm-hmm.
Yeah.
They go through security.
When they open it up for the planning commission, there's actually that security staff there that's during that time. But shoot, I could come down and be the security staff.
Yeah, I'm happy to meet here. I would think that in the evenings, I would think it'd be important for us to coordinate with the judges and get their input.
Sure.
Thanks. Okay, with that, it is our point on the agenda for public comment. Public discussion today. Seeing none, we'll move on to office business. We got payroll and warrant.
Mr. Chairman, move for approval of County Road and Motor Vehicle payroll, total amount of $129,424.73 as presented, and note that it's been reviewed and signed by 2 auditor's office representatives.
I second.
All in favor?
Aye.
Aye.
And moving on, move for approval of fund expenditures as presented in the total amount of $641,291.93. And note that this has also been reviewed by 2 representatives from the auditor's office as well as the county administrator.
I second.
All in favor?
Aye.
Aye.
That brings us to the consent agenda. We have 5 items on it this morning.
Mr. Chairman, move for approval of consent agenda as presented with discussion.
I second with discussions on items 2 and 3.
Discussion?
On item 2, we are creating amending the 2018 service awards. Excuse my ignorance here, but a total of 655 personal leave hours awarded to employees. Now, looking through this, we're looking at the list of people, and this is people that have served for a length of time, and they're getting hours awarded. Are these paid hours awarded, or what are these hours awarded?
They're actually, additional leave hours that they're granted for the award that they've received.
So in essence, they're getting paid and they don't have to be here. Is that what it is?
Yeah, be like additional vacation hours.
Okay. And this is just people that have been here a lengthy period of time, with the fact that we didn't include one person here that the reason why this is on here is Robert Mendez.
Correct.
He should have been on there and he's not. 15 years of service.
Yeah, on the original resolution, he had not been included. This is being proposed to correct that.
Okay. That's why I just wanted clarification on what that was. And on item 3 is the memorandum of understanding between Franklin County and the Historical Society. Now, a couple weeks ago, Keith, it wasn't on the agenda. I went back and looked at the agendas, but you were talking about the Sacagawea Park Heritage Days.
Correct.
You asked for that to be funded.
They had requested it. I was just bringing it before the board for your consideration.
And I've looked into this fund now that I've had a chance to just sort of getting a grasp of everything that we're dealing with here. I realize this fund is well funded. And it seems to me, in looking through the disbursement of funds, that they're only happening on even years. And it looks like that they're not being awarded throughout. And I was just curious as to what's the justification for these funds to be dispersed, because Connell has the Heritage Museum up there that's honoring our military now, and it's the Old Town Park at 350 West Adams. I haven't seen them receive any funds. I think that's something, when they're honoring our military, I would like to see them. How do we get the word out to these people about these funds, that they're available, and the amount of money that we have to disperse? I'm just curious.
I can answer for Connell. Connie's on the board, and they have to request it. You just don't step up and...
She hasn't requested it?
They haven't gotten their board to put a request together yet.
Are you working with her on that and doing that? Good, because I think that's something that's justified.
But they need to, anybody needs to request it. You just don't...
Right, I understand that. I know that they got to request it, but do they know about it? That's my point.
They have in the past, but it's been a number of years that they got a $5,000 grant.
Because I'm reading through this here, and it says that the Franklin County Historical Society mission is to preserve and promote the history of Franklin County through educational publications, programs, and the operation of the Franklin County Museum. Now, also in here was this about this gentleman here, and the fact that we are connected somehow to this magnificent place, first described in writing on October 13th, 1805, in the journals of William Clark and Meriwether Lewis. And this was right down here at Sacagawea. So I think that looking at this, that maybe the Sacagawea Park Heritage Days is something that does qualify for this funding.
So, Mr. Chairman, if I may weigh in here, I think we're talking about two different things.
This is the dinner, I realize that.
Yeah, the MOU is a dinner, and since we're discussing the consent agenda, I'd be happy to pick up the historical aspect after we move through this. But the MOU for the Historical Society dinner is a no-cost exchange, and it's reflecting the museum's support for the restoration of the courthouse. And I think once we get through the consent agenda, I'd be happy to speak to the historic funding, where it's been applied, and the fact that it's got some limitations on it.
Yes, I realize this is about the dinner, and on that, is this a fundraiser dinner?
They do solicit support from their members at that dinner.
Their members? But
the members of the Historical Society that attend this function.
The existing members, then they're free access?
Yeah.
Okay. And who actually is paying for the dinner? Is it the Historical
Society pays the cost.
Is this a wash, or does the Historical Society lose money on this?
I'm sure they end up generating money through the year as a result of having this function. I mean, it's not the only purpose of the function, but it's...
I don't know that it's inherently a fundraising event either. I think you'd have to check on that.
More of a recognition of their...
It's an annual recognition, is my understanding, and they do pay costs of security and other tangential costs.
We don't typically have a lot of social functions within the courthouse. Right. We're not really equipped with a kitchen and those kinds of facilities, so it's difficult. But because, as Commissioner Peck said, their efforts in restoring the courthouse a number of years ago, we want to recognize that contribution to the county and
absolutely. I think that's
host it in our facility.
That's justified, but I'm just wondering, we're collecting these funds for historical, and this is an historical building, granted.
Sure.
But it is a dinner, and so I'm just curious as to if we're not coming out ahead on this as far as fundraising, then it's costing the Historical Society money, which could be going to historical sites. That's my premise there, but it gave me an avenue that I've got to look into this Historical Society, and I'm just curious as to how we're getting the word out to these areas, these different sites.
We typically get more requests than we're able to fund. I know of 2 additional requests just from the Historical Society. There's a fairly significant construction issue we have with the front steps of the courthouse not being ADA compliant, and they're cracking and falling away from that building, and it's going to cost a fair amount of money to replace those. We're also looking at a grant request to catalog and document a number of their exhibits that they have in storage, and help them with some storage and capacity space. But we typically have more requests for funding from this fund than we're able to provide. But the City of Connell and other local governments have requested for those funds in the past. American Legion, Commissioner, that's in Connell, that we put the new roof on their building, and we've done some things to assist certainly groups other than the Historical Society in the Franklin County area.
Well, it's funny you should mention that, because I remember seeing that picture, and it was of Commissioner Cook and Commissioner Peck at that Legion building, but it didn't mention that those funds came from the Historical Society in the picture, and I was just curious why they weren't mentioned in that picture with the 2 commissioners.
Mr. Chairman, point of order. If we could complete the work on the consent agenda, I'd be happy to have this conversation, but we are off the topic of the items on the consent agenda, and I'm still waiting to speak to item 1.
Okay,
so item 1, I understand that Ferry County can use the furniture out of our 911 center, which I think is great. There was a mention in the package that said that it was paid for with state funds, and that's, I suppose, half accurate. I want people to know that our 911 fees that we collect here locally, 100% of those go to the state. And so when the state bought that furniture for us, they were only using money that they took from us in the first place. That's okay. I still think the transfer is appropriate. It's a good use of the equipment. I appreciate the fact that it's not going in a landfill and somebody can use it. But just wanted to take the opportunity to let folks know that what the package said about the state paying for it, indirectly we all paid for it with 911 dollars collected locally. And with that, Mr. Chairman, I have no other comments on the consent and look forward to completing our discussion on the historical fund.
Okay. We have a motion and a second. Anything further? All in favor?
Aye.
Aye.
Okay, Mr. Chairman, if I may continue with respect to the historical fund, that's a fee imposed on recording of documents, if I recall. The auditors here, he'll correct me if I get it wrong, but I think that's the case. And their primary function is for the preservation of county-owned historic records, and that's the priority. And funds only get dispersed out to requesters on an as-available basis. There's no schedule that says we do it on even years or odd years. It's as requested, and then the board historically looks to see what our capacity is and whether or not we've met the needs of the county's record keeping. And then and only then will we look at providing funds further. We have provided funds to the museum in Connell, I believe to the Railroad Museum, to the Franklin County Historical Society, to the Naval Air Museum out of Pasco Airport, the American Legion building in Connell. These are just a few that come to mind. And as for any advertising that any of those organizations might do, my experience has been that they always thank the county, and certainly we have no control if they choose to thank commissioners for assisting with the process.
Okay. Anything further? Okay. Keith?
That's all I have today.
Okay. Public comment? Anybody speak to us? Peter?
Just for the record, my name is Peter McInder from the Assessor of the County. As I'd like to speak a little bit about the elected officials' cost of living that was discussed earlier. When I was approached about that subject by some of the other elected officials, being newly elected, I had conflicting feelings concerning that. Did not anticipate a cost of living when I ran. I consider it a privilege to work for the county and the citizens of our county, and I enjoy my job and what I do. I do see a need, though, to keep up with economic conditions and attract good quality candidates to run for the offices and serve the people of our county. So I think it's something that needs to be addressed going forward. How that is addressed, I would leave that up to the powers that be. But I just want to put it on the record that I appreciate the cost of living increase, but I will do my job regardless of what I'm paid. But I thank you for your time.
Thanks, Peter. Anything else for the good of the board? Hearing none, we are adjourned. We need to do signatures also.